We will call the next case, which is also the last case of today's call, you'll correct me, Norman Champine versus the Department of Transportation. It's a mini oral argument on the application, 15 minutes per side. Mr. Desmond, if you would like to reserve some of that, we would ask you to try and keep track of it yourself. And if you're ready, you may proceed.
Thank you, Chief Justice. I intend to reserve approximately 3 minutes, but I understand we'll see how the questioning goes. Christopher Desmond from Johnson Law on behalf of the plaintiff, Norman Champine. Your Honors, this case arises, as the panel is aware, out of Mr. Champine's allegation, well-founded allegation, that the state of Michigan breached its statutory duty under MCL 691.1402 to maintain its roadways in a state of reasonable repair. At issue in the present application before this court is whether or not Mr. Champine complied with the notice requirements located at MCL 691.14041. That notice requirement clearly states that as a condition to recovery, that is the quote from the statute, and I believe those words are very important to today's proceedings. As a condition to recovery, that a claimant shall file a notice within 120 days, and that notice shall inform the defendant, in this case, the Michigan Department of Transportation, of the existence of a defect and the existence of an injury. Now, there is no question in this case, it is unrebutted, that a notice was sent directly to the Michigan Department of Transportation 11 days after this incident on December 28th, 2017. A complaint was filed in the Court of Claims that contained that same information roughly 51 days after the accident on February 6th. An amended notice was then sent directly to MDOT the following day on February 7th. In addition to all of that, it is also unrebutted that on the very day of this accident, December 17th, 2017, my client, Norman Champine, after his face was struck with this 20-pound piece of concrete that came through his windshield, he managed to luckily safely exit from 696, call the Warren Police Department. The Warren Police Department promptly arrived at the scene, took possession of the chunk of concrete, contacted the Michigan Department of Transportation that very day. The Michigan Department of Transportation arrived at the scene of the accident that very day, drove the length of 696 to try to ascertain the location of the pothole that produced the concrete, took possession of the chunk of concrete, and therefore, on the day of this incident, had notice of both my client's injuries and the defect that is at issue in this case.
Mr.
With that stated, Your Honor,
let me interrupt you. Yeah, I'll see who has questions. Justice Welch.
Yes, thank you. Mr. Desmond, I do have a question. I am wondering, the statute at issue obviously requires triplicate filings. And we know in an age of electronic filing that may or may not have significance, but I think we know that there's this notice that's triggered because of, I think the triplicate copies in the old days are intended to go probably to the Attorney General and the Department of Transportation and get sort of distributed from the Court of Claims. So I'm wondering that if a complaint can serve as notice, how would that effectively work? How would the Court of Claims clerk know to alert the other departments? Realize the case, it sounds like the Department of Transportation was looped in early. I understand that. But in future cases, how would that work?
Well, Your Honor, so you're correct. It does reference triplicate. I'm not sure exactly how that requirement works anymore in light of electronic filing. But with that stated, at the time that this complaint was filed, I don't believe the e-file system had yet gone into effect inside the Court of Claims. Interestingly, if you look at the cover sheets that have to accompany the filings of complaints in the Court of Claims, that cover sheet has boxes right at the top that requires there to be, I believe, 3 copies that are filed inside the Court of Claims. And so when you go into the Court of Claims, you hand them a stack of complaints. One is for them. One is returned to the plaintiff's counsel or the courier that they send with them. There are check boxes on the top of that cover sheet by which the clerk of the Court of Claims can verify that all of those documents were filed. So that wasn't a portion of the argument from my recollection within defendant's motion for summary disposition. I don't think they focused on the triplicate portion. I could be mistaken about that. I'm sure brother counsel will correct me if I am incorrect. But I do know that in the Court of Claims, Judge O'Brien did invoke that triplicate language. It's not something that the Court of Appeals relied on either. I would say that in addition, I think I understand your concern here, but in addition to filing that complaint within the Court of Claims, we also served the complaint directly on MDOT as well. So it would have presumably gone to them from the Court of Claims, but also from us well before that 120-day window closed.
Okay, thank you.
You're welcome.
Justice Zahra?
No questions at this time. Thank you.
Justice Viviano?
No questions.
Justice Bernstein?
No questions. Thank you.
Justice Clement?
No questions.
Justice Cavanagh?
I have one. So are you asking us essentially to sort of roll back some of our jurisprudence on strict compliance in order to invoke or avoid governmental immunity?
I don't think that's necessary in this case, Your Honor. I think we win under the straight, plain language in this statute. With that said, I certainly wouldn't be opposed to this court rolling back some of its jurisprudence on those issues, both the Rowland decision, the McCann versus Brennan decision. Each of those decisions feature some very well-written, well-reasoned dissents from Justice Marilyn Kelly. I believe in both Rowland and McCann, she was joined by Justice Cavanagh, and I think in McCann, she was joined by Justice Hathaway, and Justice Weaver also joined in the Rowland dissent. But in each of those dissents, she explained that for decades prior to the Rowland decision, the well-settled law of this state was that strict compliance wasn't necessary. Substantial compliance was necessary, and unless the government could show that there was a prejudice element, which there absolutely is not here, unless the government could show that, the plaintiff's case was free to proceed. In the Rowland decision, this court overturned decades of precedent in the form of the Hobbs case. They overruled Hobbs, and they overruled a case that had been decided, I believe, just a year prior to Rowland, which was the Brown case in 2006. This court has very well-established law regarding stare decisis and the importance of stare decisis. So I understand this court could have some hesitancy on that basis to overturn Rowland, but I would say Rowland didn't have any hesitancy in overturning decades of stare decisis when it overturned Hobbs. So I think that is absolutely within the realm of this court's decision in this case. But with that said, I don't believe that that is what our case relies on. I think that under the plain language of this statute, we provided notice to the state within 120 days of the existence of the injury and the existence of the defect. There are instances where our legislature has made it clear that a pre-suit notice is necessary. And the best example of that is MCL 600.2912B. That's the Medical Malpractice Act. And so in that act, the legislature made it very clear that you shall not commence a cause of action until 182 days after you have filed your notice of intent. So we know when the legislature wants a notice to come in a specific form that precludes a complaint from serving as a notice, they know how to do it. They chose not to do that here. Instead, what they said is that as a condition of recovery, not as a condition to filing suit, but as a condition of recovery, this notice must be filed. There is ample case law from both this court and the Court of Appeals. The Court of Appeals opinion, I believe, that states this is Plunkett versus Department of Transportation, which is binding law and states that notice need not take any particular form. Now, the Court of Claims, unfortunately, and I believe Brother Counsel does this same thing in his supplemental brief to this court. The Court of Claims said, well, the term notice isn't defined in the GTLA. And so since it's not defined, let's turn to a dictionary definition. And so what troubled the Court of Claims about this case is Judge O'Brien decided that the word notice is defined as being an advanced warning of something. And so she decided that that must be an advance warning of a complaint. Well, that ignores the statutory language. The statutory language tells us what the notice is of. The notice is of the existence of a defect and an injury. It's not notice of an impending complaint, a potential complaint. It's simply defect and injury, and our notice included that, as did our complaint.
Okay, thank you.
Mr. Desmond, but there is something appealing about understanding notice reasonably to mean something that comes before something, right? I mean, when you think of giving notice, you think it's a warning of some sort, right? It's something that comes before. So is it possible that the most reasonable way to understand it is the notice in whatever form it takes has to come before the complaint?
It's not reasonable, respectfully, Your Honor. It's not reasonable to conclude that. And the reason why I'd say that is because let's say that is the interpretation. Well, how long before the complaint do I have to file my notice? Because the medical malpractice statute tells us. So it makes sense in that context. Obviously there it's more than reasonable. It's explicit from the text. But in this case, if I file my notice at noon, can I turn around and file my complaint at 12:05? If I have, I've deprived the state of any meaningful opportunity to do anything with that notice, but I've satisfied the letter of the law. So you may say, well, no, 5 minutes is obviously unreasonable. It needs to be a longer period of time. Well, who decides that period of time? Should this court today be conjuring some number of days that it deems is reasonable to have to wait between the filing of the notice and the filing of the complaint? I don't believe that that's the job of this court. I believe it's the job of the legislature to do that, and they chose not to here, unlike in the medical malpractice statute. And I think, I see I'm nearing my 3 minutes, but there is one last point I want to make toward that question, Justice McCormack, which is that there is ample case law from this court, including decisions that have not gone the plaintiff's way. Rowland says this, Maurice versus Pontiac from the Court of Appeals says this, that the intent of the notice provision is to allow the state to be able to collect evidence, to eliminate the defect before other people get injured, and to be able to talk to witnesses. That's the intent. Well, here, they had the chunk of concrete the day of the accident. They knew of the defect within 120 days and repatched 696 2 days later. So they eliminated the defect. They collected evidence. They knew who all the witnesses were. So the intent of the notice isn't to allow them to prepare for the filing of the complaint. It's to be able to do all of those things that they had an opportunity to do in this case.
You want to reserve 2 minutes and 47 seconds?
I'd love to if no one else has any questions. Thank you.
Mr. Bladen, you may proceed.
Thank you. And Madam Chief Justice, Associate Justices, may it please the court. I'm Philip Bladen, Assistant Attorney General, and I represent the defendant appellee, Michigan Department of Transportation. I first want to acknowledge that there is no question that Mr. Champine suffered a serious injury, but sympathy for Mr. Champine's unfortunate situation, no matter how justifiable, should not abrogate the legislature's conditions for lifting the state's immunity from suit. In 1964, the legislature passed the Governmental Tort Liability Act in order to create a unified system of governmental tort liability in Michigan. In section 1407 sub 1 of the GTLA, the legislature established that, quote, except as otherwise provided in this act, a governmental agency is immune from tort liability if the governmental agency is engaged in the exercise or discharge of governmental function. In other words, as a matter of positive statutory law, governmental tort immunity is the default condition of all units of government in Michigan who are engaged in the exercise of a governmental function. The legislature established a defective highways exception to governmental immunity under section 1402 of the GTLA. But as this court recognized in Rowland versus Washtenaw County Road Commission, the legislature also placed a condition on lifting governmental immunity under this exception. Under section 1404 of the GTLA, recovery for any injuries suffered due to a defective highway is conditioned upon giving the government notice of the exact location and nature of the defect, not just its existence, the specific injuries suffered by the claimant, and the names of any witnesses known to the claimant. And all of this data must be supplied to the government within 120 days of the accident. And where the state is responsible for the highway, the notice must be filed with the Court of Claims. Mr. Champine, contrary to brother counsel's argument, did not file a notice with the Court of Claims or any notice that specified within 120 days of the accident the exact location of the defect. Because he did not do so, whether you consider his notice of letters that he sent or the complaint notice, his lawsuit was properly dismissed. I'll pause here if the court has any questions, and if not, I can continue with the court's permission.
Thank you, Mr. Bladen. Justice Welch.
Yes, so Mr. Bladen, I think I'll just ask you kind of a version of the same question I asked Mr. Desmond, which is just this notion of whether the law, says triplicate filing, whether in an age of electronic it gets forwarded. In this instance, for example, did the Attorney General get served? I mean, I'm just wondering how this would work if the complaint serves as notice.
I think that creates a conundrum for the clerk of the court, because if the complaint is supposed to serve as a notice, they have a statutory duty under MCL 600.6431 to serve copies or send copies of the notice to the appropriate department or the state agency that was sued, and also to the Attorney General, and also to keep a copy, of course, on file at the Court of Claims. If the complaint can serve as a notice, the Court of Claims doesn't know whether or not it's supposed to serve that on the other governmental agency or on the Attorney General, or whether or not it's supposed to issue a summons. And I think we mentioned this in our brief. I mean, I don't think the legislature anticipated that the Court of Claims clerk would be commandeered as a process server for the plaintiff in this situation. And so it creates a question, a problem for the Court of Claims clerk to how to handle that particular pleading.
Thank you.
Justice Zahra.
No questions. Thank you.
Justice Viviano.
No questions. Thank you.
Justice Bernstein.
Hey, counsel. Good afternoon. Welcome. I just have a few questions. Again, I go with my usual theme. Things just kind of have to make sense to me. And I think the law has to really make sense. And I think people have to see it in such a context that it doesn't appear as though there's games going on. And that ultimately, I think we can all agree that we need to focus on the ultimate pursuit of justice. So the question I'm going to kind of contain to you, or going to ask to you is that how was it that the state was poorly served in this case? What is it in this situation as it pertains to justice was not, how is the state not, how is there not justice in the situation?
Well,
by the way that notice was filed,
yes,
the way they did it.
I think if I
and what is and I'm sorry, and what is it that you're concerned about? Like from the state perspective, what is the injustice that will arise out of this situation?
Well, I disagree with Brother Counsel's characterization that the state was not prejudiced by the lack of specificity with respect to the location of the defect, and here's why. There is a separate notice provision for highway defects under 1403 of the GTLA, which says that if the government, even if the particular defect might arise in the highway, that if the government does not have advance notice of that particular defect before the accident, or if it does have notice of it before the accident, but not a reasonable opportunity to repair it before the accident, it still should not be held liable under the highway exception. And the purpose of being notified of the exact location of the defect before the lawsuit is to allow MDOT, or in this case, to investigate whether or not it had notice of the defect, the specific one that caused the injury.
So, counsel, I want to get into that. I want to get into that with you a little bit, and maybe correct me if I'm wrong, and I please invite you to do so. Hadn't there been some issues or problems in this same location before this massive piece of concrete fell? Like, hadn't there been some other issues or problems that had occurred prior?
You mean on the entire 5-mile stretch of I-696?
Yes. My understanding is, and I want to make sure my facts are correct, but isn't this like the 4th time this has happened? Before this specific accident?
Before this specific accident, yes, on 696?
Yes.
A piece of concrete went through somebody's windshield? Yes. I'm not sure what the exact number might be, but I think there were some additional incidents.
Okay, so let me ask you a question. Okay, so and I understand, like you're making your argument, so please don't, you're doing an excellent job. But like, let's just go to, I mean, and I have to be candid, you kind of started it with this, that, you know, due to the horrific nature of this injury, we shouldn't, you know, we shouldn't allow that to kind of take away from the injustice that the state feels that is going through because of the notice. So the question I'm going to pose back to you is that ultimately, like, this has been happening several times before this person got horrifically injured. The question I have to you is, it just seems a little disingenuous to come and argue this point that notice is so critical and notice is so important when this had been happening numerous times before.
Well, I think every incident is its own thing.
Right.
And as I said, the legislature had balanced the policy interest and balanced the question of, as this court pointed out in Rowland, the legislature tomorrow could completely eliminate a highway exception if it wanted to. It might say resources for building and maintaining highways and bridges are so scarce, and personnel are so scarce, that, and time is precious. We were going to eliminate this defect, highway defect.
But see, and I'll just ask you one last question. So my concern with this entire scenario, and I have to be honest, I'm a little frustrated with this, is that the state is so concerned about this, that the state has to have all this knowledge as it pertains to notice, as to this very specific location as to where this happened, which it's a huge piece of cement. So like, I mean, I don't know how you're going to figure out the specific, I don't know what the plaintiff's supposed to do. Should they go out there on the highway and start like looking around the bridge to do this? And then on top of which, after the state is so concerned about the fact that we have to know the specific location and we have to have all this information, that this had happened 4 times prior. So with all of that notice, the state did nothing. That's a problem for me. How do you address that?
I would disagree that the state did nothing.
Prior to this incident,
highway,
it happened 4 times before.
Well, that highway was reconstructed in 2000, just in the following spring, just a few months after this accident occurred, completely reconstructed. And that planning for that reconstruction was years in the making. So MDOT had been planning to reconstruct that highway for years, and it did. The notice would have made all the difference in the fact that it happened 4 times before. Counsel, thank you very much. I have no further questions.
Justice Clement.
No questions.
Justice Cavanagh.
So you and I think the Court of Appeals as well put a lot of weight on the phrase condition to any recovery. It doesn't say condition to filing suit. Obviously, it says condition to recovery. Why does a condition to recovery necessarily have to be satisfied before filing of a complaint?
Well, I'd start with just the basic notion that this is a tort. So the 4 elements of a tort, is obviously everybody well knows: duty, breach, causation, and damages. If you're precluded from recovery of damages, you're taking away one of the elements of a tort. So therefore, there's no cause of action. Second, as this court, not only in Rowland, but this court in Rowland recognized that failure to comply with this notice requirement required dismissal of the lawsuit. And when this court reiterated Rowland in McCahan, in other words, it's not just Rowland, but McCahan reiterated Rowland. McCahan, of course, interpreted the governmental tort notice in the Court of Claims Act under Section 6431. But in doing so, this court compared the language of the 1404 notice with the 6431 notice and noted that they were both barred to claims language. So I think the combination of the fact that it's a standard, we're talking about a tort here. If you negate the cause of action, then you negate the damages, then you have no tort. And also this court in Rowland and McCahan both recognize this to be part of claims language. And I would add one thing, just pure logic. Why would the legislature create a provision that says you can go through the entire lawsuit and subject the state to litigation and the costs and burdens of that? But at the end of it, because the plaintiff did not supply the correct notice, they're deprived of any recovery at all. I don't think it makes any sense. I think logically it has to be interpreted that way. I can even go back further on that as well. There's a case called, Sykes versus the city of Battle Creek that goes back to 1939, which interpreted a prior iteration of this particular notice requirement. And that is 288-660. And I'm going to read the statute that issue at that case, which was 1 Compiled Laws of 1939, Section 4230. The statute at that time stated, in the event damages are sustained by any person, either by bodily injuries or to his property, because of the defective condition of any highway, street, bridge, sidewalk, crosswalk, or culvert in any city or incorporated village of this state, where written notice of such injury and defect is now required by law to be served upon such village or city, before recovery can be had, it will be necessary to show that such person did serve written notice upon said city or village within 60 days from the time of the happening of such injury. This court in 1939, at page 663 and 664 of the opinion, stated it held the plaintiff was bound to give such notice within the period required, and for failure to do so, her recovery is barred. Judgment for the city was affirmed. In other words, the summary judgment for the city was affirmed and interpreted similar language to what is in the Section 1 of 1404, which is the bar to claims language. And I can even go one additional point beyond that, is that more recently in this court in Epps versus Four Quarters Restoration, LLC, which I believe is 498 Mich 518 back in 2015, that wasn't a governmental tort case, but it was a case involving a unlicensed contractor who was barred from filing claims. This court had to define what a defense was in that particular case. And it said at page 530 of the opinion, a defense is that which is offered and alleged by the party proceeded against in an action or suit as a reason in law or fact why the plaintiff should not recover or establish what he seeks. That which is put forward to diminish plaintiff's cause of action or to defeat recovery. And that was a citation to, this court cited Black's Law Dictionary. So in other words, what the language is in Section 1 of 1404 is a defense. And it's a governmental immunity defense because it's this court recognized in rule and it's a condition precedent. And MDOT was prejudiced by this failure to file a notice of exact location nature of the defect, and it should prevail. The Court of Appeals was right.
Thank you.
Mr. Bladen, I'm going to use up a little extra time. You heard that I asked Mr. Desmond why the most reasonable understanding of the word notice is what I think you say it is. It's something in advance of something else. Usually if you give notice, it's something you give ahead of doing something else. But on the other hand, we have, in other statutes, the term advance notice or 10 days notice. We have notices modified by something more specific. So that makes me think that maybe notice might just mean notification. Maybe it just means your client needs the information that's specified. But given that there's no modifier of notice, what's your response to that?
Well, I would say that first reading the statute, it says Section 4 sub 1 states, as a condition of any recovery for injury sustained by reason of any defective highway, the injured person within 120 days from the time the injury occurred, except as otherwise provided in subsection 3, shall serve a notice on the governmental agency of the occurrence of the injury and the defect. It doesn't say serve notice. It says serve a notice, which implies that it's a specific thing that it must be of some sort. I think you also look at the textual clues. I shouldn't say clues, but actually there's strong textual evidence all over both MCL 691-1404, and if you compare it to 6431, that says that must be filed in advance. The first thing we look at under subsection 2 is that the notice filed under 1404, the legislature said, filing such notice shall constitute compliance with section 6431 of the Court of Claims Act. Such requiring, and that's provision requiring the filing of a notice of intention to file a claim against the state. Now, in my view, I think the legislature included the phrase requiring the filing of a notice of intention to file a claim against the state in section 1404 because it wanted to alert claimants that that was what this notice is. The notice under 1404 is a notice of intention to file a claim against the state. That's strong textual evidence that the legislature, that's what it believed it was doing here. Second, that section 2 of 1404 also gives, as we talked about in our brief, pre-suit investigatory powers. It gives the power of the government agency, not the claimant, the government agency, the power to put the claimant's witnesses under oath, not just about the defect, but about the amount of the claim and their injuries, so that it could do a pre-suit investigation, perhaps engage in litigation, settlement discussions, and so forth. So it was clear intention that the legislature wanted the notice to be filed first, then the complaint. Then subsection 3, you have the notice for tolling provision. There would make no sense to have a tolling provision for the notice period if you could simply file the complaint. And if you do a comparison between the language of 691.1404 with subsection 1 of the Court of Claims Act, where the Court of Claims Act says that you can file the notice of intention to file a claim within the notice period or the claim itself. In this court in Bowserman recognized that essentially means you could file the lawsuit or the claim or the notice within the notice period. That language is specifically absent from 1404. In other words, that's strong textual evidence that the legislature did not intend that a notice, that the complaint could be filed within the notice period instead of the notice, as comparison to 6431. And 6431 also doesn't have the pre-suit investigative powers or the tolling provision. And I think just logically, you also, under the GTLA general statutory scheme, if you permit someone to file a complaint in lieu of a notice within the notice period against the state only, it would only be against the state because of the nature of that you have to file the complaint and the notice with the Court of Claims. You would create a two-tiered system where the state, you can file a complaint against them with a notice, but against the local governments, you can't do that. I don't think the legislature intended that.
Thank you, counsel. Thank you. We've used way more than your time. Mr. Desmond, you have a little bit of rebuttal time.
Sorry about that. I wasted some of it while on mute. Justice Bernstein, I thought you were about to ask a question that has popped into my head during Brother Counsel's argument regarding the exact location. You stated that one of the reasons for needing the exact location is so that the state can go to the defect and figure out, is that a defect that we were previously aware of? Did we have notice of that so that we could be held liable under the highway exception? Well, if that's the reason, why 2 days after this injury occurred, did the state go and repatch all of the potholes within this stretch of road? Because by doing that, you're essentially spoliating evidence. There's no ability for anybody to figure out where the defect is if the state goes through and patches everything. So with that said, again, the day of this accident, MDOT is at the scene. Marlon Spinks, MDOT engineer, testified that I drove the area and was not able to locate the defect myself because of the number of, his quote was, open areas. 2 different police officers, Officer Taylor from Warren Police Department and Detective Chisholm, who was the officer in charge of this investigation, both testified. We drove that stretch of road. We looked. It was impossible to figure out where this concrete came from because there were, the estimate, and maybe he was being hyperbolic when he said this, but the testimony was thousands of potholes in that stretch of roadway. So the Warren Police Department, with all their authority and power, the Michigan Department of Transportation, with all their authority and power, none of them are able to figure it out. But Johnson Law is expected to be able to do it before the road has been paved over, which occurred before Norman Champine ever even contacted us. To try to hold an individual who was injured, by the way, traumatic brain injured, to try to hold an individual to that standard in light of the fact that there is an affirmative duty on the part of the state under MCL 691.1402 to maintain their roads in a reasonable condition. They breached that duty, and they're trying to not be held responsible for it. And they're trying to do it on the basis of a hyper-technical reading of this statute. So, Your Honor, I would say that that effort is improper. It should not be accepted by this court. The Court of Appeals should be reversed for the reasons stated in this dissent, and it should be remanded back to the Court of Claims for further proceedings. Thank you.
Thank you, Mr. Desmond. Thank you, Mr. Bladen. The case will be submitted. That ends today's case call. We will be back here tomorrow morning at 9:30.